Well, we began our conversations with the prisoners, that the conditions there were very much worse than here.
When you say here, where are you referring to?
Ternopoli, where we were then. Mr. Alic and Mr. Icic both talked about massacres of large numbers of men in Keraterm. There was talk of a massacre of 150 men in one night. Well, one's head was spinning. We had beheld this remarkable sight of these men, and now they were talking about somewhere else. And we conducted those interviews, first of all, by that fence, the barbed wire fence that you saw.
October 1992, the Security Council decided to establish a commission of experts for serious violations in the former Yugoslavia. And this was, in essence, a fact-finding commission. The mandate was to analyze existing information on violations of serious violations of international humanitarian law, as well as to collect some additional information and to report its conclusions on such violations to the Secretary-General of the United Nations.
As a response to the terrors inflicted on the peoples in the region, the United Nations Security Council established the International Criminal Tribunal for the former Yugoslavia in 1993. It is the first international tribunal of its kind since the Nuremberg and Tokyo trials.
I shall now give the floor to those members of the Council who wish to make statements following the voting.
The serious violations of international humanitarian law which have been taking place in the territory of the former Yugoslavia have outraged the conscience of humanity. It is with deep sorrow and concern that the Brazilian government and the Brazilian society at large have received the repeated news of unspeakable atrocities committed within the context of this senseless conflict on European soil, which must be brought to an end.
Pursuing an unwavering course of halting war crimes, Russia cannot remain indifferent to the flagrant and mass violations of international humanitarian law on the territory of former Yugoslavia. Murders, rapes, ethnic cleansing must all be immediately halted. And those guilty, whatever camp they may belong to, must be duly punished.
There is an echo in this chamber today. The Nuremberg principles have been reaffirmed. We have preserved the long-neglected compact made by the community of civilized nations 48 years ago in San Francisco to create the United Nations and enforce the Nuremberg principles. The lesson that we are all accountable to international law may have finally taken hold in our collective memory. This will be no victor's tribunal. The only victor that will prevail in this endeavor is the truth.
The tribunal is located in The Hague, long considered the center of international humanitarian law. From its seat in the Netherlands, the tribunal conducts trials according to established rules of international law.
The Hague Conventions were adopted here in this city in 1899 and then revised in 1907. And they are of crucial importance because for the first time states got together to try to place restraints on the power of belligerents in armed conflict, in international armed conflict. This was really a major turning point in the history of mankind, and that's why I would say that what the famous scholar, German scholar and Nobel Prize winner said of the Hague Conventions, namely that they were a misprint in world history, is totally wrong. No, they were a great achievement. They were subsequently revised and updated in, for instance, in Geneva in 1949, and then subsequently again in Geneva in 1974. And those conventions, Geneva Conventions, tend to protect the victims of war, in particular civilians, prisoners of war, people who no longer take part in any combat, the sick, the wounded, and also civilian objects such as hospitals, churches, and so on. So in a way, an effort was made at that stage to try to limit the inhumanity of any war.
You know, if you said to me as a former general, what is a war crime? It's very easy. A war crime is someone who kills innocent men, women, and children, someone who rapes women, someone who steals property in wartime, and someone who kills or injures prisoners of war after they've been captured. That doesn't take any great education. Every military man certainly knows what the criteria are.
The tribunal's establishment demonstrates the consensus of the international community that war crimes and crimes against humanity should not occur with impunity.
The mandate of the tribunal was established by the Security Council, UN Security Council, the body of the UN which set up the tribunal, and its mandate is to prosecute and punish those who have committed the worst atrocities in the former Yugoslavia since the 1st of January 91. So therefore the tribunal was set up to dispense justice and to, in a way, prompt reconciliation by doing away with this hatred, revenge, animosity between the various groups, and it was also trying to replace collective guilt with individual guilt. Namely, those who have committed crimes must be punished, not the whole ethnic group to which they may belong. This is the main mandate of the tribunal, and I think it's doing a very good job.
The tribunal depends upon the will of the international community and the cooperation of member states, especially countries that emerged from the former Yugoslavia, to enforce its mandate.
Is that the tribunal did not have a police force, does not have a police force. States are obligated under international law to cooperate, and a good part of that cooperation involves the execution of arrest warrants, and many states just simply refuse to do so. And when I became president, this non-cooperation rose to the level of non-compliance, and then as I said to the Security Council, had reached the level of obstructionism. And so it made the job very difficult. That, of course, has turned around, and S4 has begun to execute arrest warrants, and other states have passed the necessary implementing legislation.
Unambiguously that the order issued is a binding order triggering the obligation to comply by Croatia and the defense minister under Article 29 of the statute.
Since 1993, the tribunal has developed into a fully fledged international criminal court. The tribunal has had the same three-part structure since its establishment: the judge's chambers, the office of the prosecutor, and the registry. Though housed in the same buildings, these main branches carry out mandates that are clearly distinct.
A line owned by the Zenica PTT, which was diverted to the Third Corps.
Correct. At the time, it was the only...
Well, chambers are the core, if you like, of the tribunal. They provide the staff for the courts, the judges first of all, and also the support staff. The responsibility of the prosecutor is to bring the indictments and to try to put forward the cases. And as such, the prosecutor then is a party to the proceedings. The responsibility, of course, of the judges is different. It is to try the cases and to decide the cases. And as such, chambers are completely independent from the prosecutor.
The judges hear the cases presented by the prosecution and the defense. They determine the guilt or innocence of the accused, and if the prosecution case is not proved beyond a reasonable doubt, then the accused pending appeals is released from detention. If the judges reach a guilty verdict, they will serve a sentence upon the guilty party. The Office of the Prosecutor is responsible for launching investigations. Like in a national court, the prosecutor builds criminal cases against individuals and presents them in court. The prosecutor does not charge states or ethnic groups with crimes.
Commander of the Drina Corps was General Jovanovic. Am I correct?
Da. Yes.
C'est de même que dans un système national. Le ministère public, le parquet.
It's the same in a national system. The Public Prosecutor's Office is the authority charged with prosecuting, with investigating and prosecuting people guilty of certain crimes. And in this particular case, what is at issue are genocide, war crimes, and crimes against humanity. So one could say that the Office of the Prosecutor is the main motor driving the tribunal, because what it does is bring out indictments which allow trials of the guilty parties to be held, that's to say, of the people accused of those crimes. The Registry is in charge of the overall administration and judicial organization of tribunal proceedings. This includes the running of the detention unit, where indicted individuals await the completion of their trials, the provision of high-quality legal aid to the accused, and protective measures, when appropriate, for witnesses.
The Registry has to be neutral, in a sense, particularly because it has responsibilities with victims and witnesses, and ensuring that those victims and witnesses are supported and testify in the court and are protected if necessary. It also has to deal with defense counsel and ensure that the accused has representation, adequate representation, and has to provide a legal aid system that is to pay for accused who are indigent, who are not able to pay for their own defense. So it's very important that the Registry be a neutral body and maintain its neutrality.
The tribunal is thus the single home to a variety of functions, which in most national criminal law systems are discharged by various legal or administrative bodies.
The selection process of the judges is provided for in Article 13 of the statute, which emphasizes that the judges have to be of high moral character, impartiality, and integrity. The process is a bit technical. I'm afraid I have to go into some details. The states have to propose up to 2 names, no 2 of which can be of the same nationality. The proposal is sent to the Security Council of the United Nations, and the Security Council will have to prepare a short list of at least twice as many judges as needed, which is 28 names, or 3 times as many judges, but not more than 3 times, which is 42 names. The short list then is sent to the General Assembly for the member states to vote on the judges, and the judges are elected by a majority of votes and in the order in which they have the higher number of votes. There is a reform, and the idea is to have, in addition to so-called permanent judges, ad litem judges, that is, judges that will be called to sit only on a specific case.
To make the solemn declaration.
I also didn't know that I would be able to fit in and blend with the other judges from different countries. But as you know, the legal profession is a profession where lawyers always agree to disagree. So when you come here, you meet people from different parts of the world, and you accept them because you have one thing in common, and that is all of you are lawyers, mostly the people we work with, the judges and the legal support. So we tend to mix amongst lawyers, and we have quite a number of common concepts in the legal profession. So that doesn't make us sound or look very different.
Call the case, please.
The unique international system of trying war crimes draws on both the common and civil legal systems.
The early challenges were really quite immense. There was just nothing here at the beginning, so it was necessary to obtain professional, qualified and experienced staff to do a very, very difficult job, and to get them together in a very, very quick period of time. And that included setting up the structures of the office, recruiting the staff, and dealing with the international community and NGOs. And I was very active in doing all of that, so that by the time the first prosecutor, Judge Goldstone, arrived in August '94, he was able to find at his disposal a fully functioning prosecutor's office.
There had never been such a thing as a criminal tribunal in the UN system. So the rules were not devised for it, they were contradictory of it, and so it meant dealing with a very difficult bureaucratic situation to build the office. And then, of course, it was difficult to get the sorts of people to come to The Hague that we needed quickly.
When the tribunal was first established, investigating cases was a difficult process. With little to guide them except their prior experience in national systems, the tribunal prosecutors began the work of mounting investigations on what was, in some cases, hostile territory. Investigators from different backgrounds merged their techniques to develop criminal prosecutions that are international in character.
When we look to the background of investigators at the tribunal, we draw them from many countries. I think there's something like 35, 40 countries represented in our investigation staff. Training methods are different from country to country, and I think it's fair to say the legal regime at the tribunal is different from any other legal system. So when we're looking to engage investigators, we look more for a certain set of skills. We look for investigators who've had significant training in criminal investigation techniques, who can master interview situations, but who have also had considerable experience in protracted investigations where the answers don't come easily.
What happened on the 22nd of August 1994?
Investigating war crimes atrocities isn't typical police work. Investigators are forced to confront hard evidence of tragic events. The success of the investigations depends in part on the willingness and the courage of witnesses to assist in exploring the stories behind the scenes where the crimes took place. The prosecution conducts criminal investigations, which are a unique mixture of academic international law and the nuts and bolts of a police investigation. The prosecution must thoroughly examine all of the evidence to determine whether it's sufficient for an indictment.
The investigative work is primarily done here in the office in The Hague. We collect and analyse documents and other evidence of alleged war crimes. Cases are selected on the basis of criteria set by the prosecutor and prioritised in line with available resources. The cases are then assigned to one of the investigation teams. When the investigation is assigned to the team leader and legal advisors formulate the investigation strategy. Each member of the team is assigned set responsibilities and management review progress. During the entire process, we continue to collect evidence. A time frame for the investigation is set, and missions to the area where the alleged crimes took place are planned. Part of the investigation takes place in the field, in the area where the alleged crimes took place. Usually the local investigation starts with the interview of witnesses. We have to obtain as much specific information as we can, and because we work through interpreters, we have to ensure that there are no misunderstandings. After we obtain statements, investigators and scenes of crime officers will go to the alleged crime scene and test the information that we have received. We'll also look for corroboration of the information. For that reason, the scene of the crime is photographed, sketched, videotaped, and we also look for physical evidence such as cartridge casings, bullet fragments and projectiles. Exhibit number 42 is a projectile.
15.5.
Partially obscured with dirt.
That's 6 foot 8 inches.
Refresh it. Exhibits number 42 and 44. If there are indications that the crime involves mass killing, the investigators will seek the assistance of one of the forensic teams, and once sufficient information is gathered, the exhumation process commences. We are here in Ponte in Kosovo, where the British exhumation team is conducting an exhumation of the site.
We are members of the British forensic team. The team is a fully integrated standalone team which is involved in the recovery of suspected murder victims, and we take the process from the tasking by ICTY. The case will have been investigated by an ICTY investigator. A reconnaissance is carried out in cooperation with the army, and of course the soldiers involved in the dismantling of explosive devices together with dogs. An assessment is made of the type of excavation that will be necessary. We then return with military assistance. We are guarded by the soldiers in whose sector we are operating. On the occasion I've been deployed, we attend with the Norwegian army, who have a armoured brigade, who assist us with the digger, and it's important to note that the digger only removes the soil above the site of the body. The digger driver is very experienced, the family members are present and clearly very emotional. It is necessary to ensure to them that there will be no disturbance of the body. Then once the body is uncovered, it is hand-dug by police officers, it is photographed in situ, it is assigned an exhibit number, the scene is photographed, and the normal method of an investigation of a homicide takes place. To say that the victims, and there are 8, are reported to have all been killed at the same time. They're all women and children, and it's not until we actually have an autopsy that the word of the local people can be given credence, because when the autopsy takes place and ballistics are found and the manner and pattern of the shooting is established, then you can take it to a court of law to support a case of homicide.
From the exhumation site, the bodies are taken to one of the Tribunal's forensic pathology centres. Here at Visoko in Bosnia-Herzegovina, John Clark is overseeing the post-mortem examinations by his team of international experts.
Mm-hmm. And this is a sort of typical finding. Here at the mortuary is our purpose is to try and find out why these people died, and also try and assist with identification, although that's not as easy as possible. You've got to bear in mind these people have been dead for 5 years or so that brings with it a lot of difficulties. The bodies are decomposed, the graves have also been robbed, and the bodies are disrupted. So there are limitations on what we can tell, but on the other hand, it's amazing what we can still find as well. What we do, in brief, the process is that the bodies are brought here. When we're ready to deal with them, they are initially fluoroscoped, that's a sort of form of X-ray, and that will show us up the bullets and any other metal material in the bodies. It gives us a guide as to where they are. Then the body will be brought onto the table like this, and we will do an examination. First of all, we look at the clothing, remove the clothing, and look for any identification items on it and other possessions which might help identification. And then look for injuries, and that's our main purpose. The bodies will be preserved in various states. Some are very well preserved, like this one with the skin and soft tissues. Others are more reduced to skeletons. Perhaps the best evidence of injuries is damage to the bones, because the bones are permanent. So we will look at the soft tissues, but primarily look at the bones for injuries. Now it's not just pathologists in here, of course. We have a big team, about 20 people, different disciplines. Pathologists, we have anthropologists who help us in looking at the bones, not only in interpreting the injuries, but in trying to tell us how old this person is, whether it's male or female, get an idea of the height of the individual. and helping reconstruct broken bones as well. And in the end, we usually get fairly good evidence as to the cause of death. All these people here we're finding multiple gunshot injuries all over the body, sometimes to the head, to the trunk. Sometimes just one shot, sometimes up to 10 bullet injuries. So we can usually give the cause of death in the end. Once we've dealt with it, we remove the clothing and the possessions. They're all carefully examined by scenes of crime officers, and then everything is compiled together in a report, and then we will hand the bodies back to the Bosnian authorities.
After the post-mortem examinations, the process of identification commences. Bodies are returned to family so that they can be buried with dignity. The investigation process continues in The Hague with the processing of evidence from the exhumations and crime scenes. When we return from a field mission, all of the evidence collected, such as bullet casings, fragments and other evidence, is processed and examined in more detail. Witness statements, along with evidence from crime scenes, exhumations and other sources, is used to support the indictment. After final approval by the prosecutor, the indictment and supporting material are presented before a judge. The indictment has to be confirmed by a judge for the issue of arrest warrants. After this, we continue with preparations for the trial, which will take place after the arrest of the indictee.
Initially, all indictments were publicised. Since 1997, the prosecutor has mainly used standard sealed or so-called secret indictments.
C'est malheureux qu'ils soient appelés secret indictments, c'est-à-dire
It's unfortunate that they're called secret indictments, because, for me, I would call them just regular indictments. I was surprised to see that the indictment is made public even before the accused is arrested. Now, you can imagine how it makes it even harder to arrest people if they know in advance that someone is looking for them. So, a regular indictment is known as secret here, meaning that the indictment is not made public until the accused is in detention. That, of course, is what happens in national systems. We are simply going back to what is normal. What I mean is, the indictment is not made public before the person is picked up, because we thought that if it was made public, the accused would have surrendered to the tribunal. Now, that's a dream. We see that. Indeed, we see it confirmed every day. Because I am a prosecutor with too many people against whom there is an arrest warrant and who are not in prison.
Trop de gens sous mandat d'arrêt qui ne sont pas en prison.
The Yugoslav president Slobodan Milosevic and 4 other members of his regime have been indicted on charges of crimes against humanity in Kosovo. Arrest warrants have been issued and their assets worldwide have been frozen. The announcement was made by the chief prosecutor of the War Crimes Tribunal, Louise Arbour.
There is credible basis to believe that these accused are criminally responsible for the deportation of 740,000 Kosovo Albanians from Kosovo, and for the murder of over 300. Command responsibility again has its legal roots in the Nuremberg and Tokyo trials, and it's a concept that the Security Council put squarely within the mandate of the tribunal. So it is a basis for charging. You could charge someone on the basis of their responsibility as leaders for acts committed by their subordinates, when you could prove as a prosecutor that they knew or that they should have known that these criminal activities were going to be committed by their subordinates, or alternatively when they fail to punish their subordinates, having found out that they engage in these kinds of practices. So in a sense, it's an alternative to the direct, immediate personal responsibility. So a leader, for instance, a military commander, can be guilty either if he ordered or commanded a particular crime to be committed, or if he knew that it was being committed by his subordinates and did not use his command position to stop it.
With no enforcement agency or police force of its own, suspects may come into the tribunal's custody in several ways. The accused may be apprehended by the national police of the countries in which they reside. The accused may be apprehended by the international forces deployed in the former Yugoslavia. In some cases, suspects voluntarily or supported by their government give themselves up.
Croatian soldier surrendered to officials of the European War Criminal, former general and politician Dario Kordic.
Izrazio nadu da je to podsjetnik kako su svi potpisnici Daytona dužni.
Once arrested, the accused is transported to the Netherlands, and upon arrival is transferred to the UN detention unit near the tribunal. Within a few days after arrival, the accused, after being provided with the indictment against him or her, will appear in court to enter an initial plea of guilty or not guilty before the judges. While awaiting trial, the accused resides in the detention unit. The detention unit was built for the tribunal within one of the largest Dutch penitentiary facilities. The accused persons remain in the detention unit until completion of their trials.
This is a remand centre which serves the ICTY, and as such it differs from a remand centre in a national jurisdiction. First of all, the type of accused that we have generally are not habitual criminals who would have had previous jail experiences in juvenile remand centres, etc. So they don't have, for the most part, a criminal background. So for the first time in their lives, they're experiencing the denial of freedom. Many of them may have held high public office prior to coming here, maybe office with privilege attached to it. Therefore, it's difficult for them to come to terms with the denial of freedom. We have spiritual advisors both from the Serb Orthodox Church, from the Roman Catholic Church, and a Muslim imam. We allow from time to time certain food items come in that are typical of the Balkans diet, etc. During the day there would be an hour's exercise in an open exercise yard where one can go for a run or a walk or whatever in the fresh air. In addition to that, we have a library service. We have arts and crafts class, which takes place twice a week, and we run English classes for them. All of those factors make it different to a remand centre in a national jurisdiction.
Aside from the detention unit, the registry is responsible for ensuring that the accused has adequate defence representation. In the majority of cases, when the accused is indigent, the tribunal provides all necessary funds to pay for the defence.
Good morning, Mr. Ali.
Morning. Hi, not so bad.
We are a
So
registry office, which basically means that we're a neutral court administration office, and our work really consists of two components, one of which is to ensure that people who are accused by the tribunal or who are suspects of the tribunal obtain a proper defense. The second component is that people who are in detention of the tribunal in The Hague, in the detention facility, that their rights as detainees are observed properly by the tribunal. Both these components entail a lot of administration by our office, so that on a day-to-day basis, facing requests by accused or detainees, we deal with these matters to ensure that these rights are secured.
Once the defense and the prosecution have prepared their cases, the trial is ready to begin. As a court of justice, trials lie at the heart of the tribunal's work. Trials are conducted in public and are to the highest international standard. The prosecution and the defense are the two parties in each case. The judges perform the key role of determining guilt or innocence and pronouncing sentence in those cases where the accused is found guilty.
The International Criminal Tribunal for the former Yugoslavia is now in session. Please be seated.
The judges are divided into 3 trial chambers consisting of 3 judges each, a number of ad litem judges who will serve only during one trial, and one appeals chamber consisting of 5 judges. The trials generally unfold according to the same broad pattern. During pre-trial proceedings, a pre-trial judge will narrow the range of issues and evidence to be explored. The trial takes place in an adversarial setting, where the prosecution presents its case and witnesses, followed by the defense. While the judges have the authority to order the production of additional evidence and witnesses, the primary responsibility for presenting evidence rests with the prosecution and the defense.
Half the summer is, the remainder 3 weeks later. And of course
The tribunal is the first international court to try gender crimes under international law.
Remind that rape has been listed for the first time in the history of humanitarian law as a crime, and that the systematic
we use that phrase gender crimes. What we're really talking about are different forms of sexual violence, and we're talking about sexual violence that occurred during the armed conflict in Yugoslavia, but that might have been committed against men and women. And so we're not talking about crimes against women, but we're talking about crimes against sexual integrity that could take many forms, such as, I guess the most common form is what people think of as the crime of rape. That's a type of gender crime, but it's really sexual integrity. But gender crime could go toward forms of sexual mutilation, and we've already put forward evidence of that, and we received convictions at the Yugoslav Tribunal for mutilation of genitalia. There's evidence of mutilation of other parts of the body. Gender crimes could go to forced nudity, male and female being forced to remain in a state of nudity within a public sphere because they are members of the other side of a conflict. Or gender crime could just go to threatening your physical integrity or forcing you to watch someone else who is being sexually assaulted and sexually violated. So that word gender crimes has a very significant meaning, but I think if I were to translate it in a much more, I think, usable phrase, I would say they're crimes of sexual violence in all their manifestations.
Every evening, I think. He raped me and number 85 together in the same bed, with music playing. Swan Lake, actually. He did that sort of thing, and he told me, "I've killed your brother. What do you want? What can you do about it?" That's what he said. And I sort of swallowed that. And I said, well...
I would stress this as a major achievement of the tribunal. For the first time, one of the first judgments of the tribunal, which was delivered back in 1995, laid down a basic principle, namely that also violations of law committed in civil wars may be regarded as war crimes. Previously, only breaches of law committed during international armed conflicts could be defined war crimes. The tribunal said there's no point. A rape is a war crime, both in case of international law, international armed conflict, and in case of a civil war. One should not make any distinction. Atrocities are atrocities and must be labeled atrocities wherever the context within which they are committed.
Well, He said he would sort of protect him and that I would be only with him and that he wouldn't bring anybody else to me and that nobody else would rape me.
It is important for the witnesses to feel safe because this war was very vicious. It was fought with so much brutality that it is very difficult for ordinary people who come here as witnesses to feel free to relive and to relive what they went through, to be able to explain in detail what happened to their loved ones, their own families, and in some cases themselves, and their property, their very being was abused. And so the tribunal has got provisions within the statute for the protection of witnesses. For instance, they may not use their actual names. They may have facial distortion so that the public can't see their faces. They may have voice distortion. But in spite of all those protective measures, it's really vis-a-vis the public. Otherwise, the accused are always present in court and they are able to see the witnesses. So the witnesses, it's important for them to be protected, and I'm glad to say we have the provisions, the statute itself and the rules, and the tribunal has got this unit which is very, very important.
The Registry of the Tribunal operates a Victims and Witnesses section to ensure proper support for witnesses who in some cases may be traumatized. The Tribunal has introduced special protective measures to ensure the safety of witnesses who are willing to testify on such very sensitive matters. The Tribunal is charged with interpreting and applying international law regarding war crimes, crimes against humanity, and genocide. In this global and historical context, judges, whose principal task is to ascertain the truth surrounding individual crimes committed in the former Yugoslavia, must proceed with great care in developing their contributions to a system of international criminal justice. When both parties have completed their presentation of the case, the judges will deliberate in private to reach their decision. If a majority of the judges finds that guilt has been proven beyond a reasonable doubt, a finding of guilty will be reached. If the trial chamber finds the accused guilty on one or more of the charges contained in the indictment, they impose a sentence.
Sentences.
A convicted person may be sentenced for a term of up to life imprisonment, which is to be served in one of the United Nations member states which have entered an agreement with the tribunal.
Ordonne la mise en liberté immédiate de Zlato Alexovski, nonobstant appel.
A sentence imposed by the International Criminal Tribunal serves a number of purposes. Every sentence points out the criminal responsibility of the convicted individual. No geographical entity, no social, religious, or political collectivity or ethnic group can be put on trial at The Hague. Only individuals in their personal capacity and responsibility can be punished.
Well, contrary to what was the case, certainly at the Nuremberg trial, this tribunal, the same for the tribunal for Rwanda, these tribunals were not given any competence over groups or organizations, ethnic groups or states. The whole premise of the tribunal is that responsibility is visited on individuals. And so inevitably, individuals, particularly in positions of leadership, link themselves to organizations like the army, paramilitary groups, political parties, and in some cases governments if they happen to be in positions of power. But the indictments and the focus of the investigation is on the personal criminal liability of individuals.
The sentences pronounced by the ICTY go beyond the personal fate of the convicted individuals. Deterring the commission of similar crimes and calling to a halt the cycles of impunity is another important mission entrusted to the ICTY.
We can say that the tribunal's decisions on both procedure and substance are on the cutting edge of the development of international law. The main trait maybe of the decision of the tribunal is that the legal issues they are dealing with have never been addressed before or never been applied since World War II.
While no court of law can stop a war, the tribunal is helping to demonstrate that the rule of law is the foundation for a lasting peace.
We shouldn't
forget that our tribunal was first conceived, created, and set up to provide a legal answer to the atrocities committed in the Balkans and those three unfortunate countries, especially in Bosnia and Herzegovina. So the horizon is very wide, that is, this is the biggest challenge we'll have to take up. Will we be able to show that a well-honed legal instrument like ours can make a contribution first to maintaining and then restoring the peace? Obviously, the President speaking with you believes that and is telling you that. And because of rigorous decisions and impartial judges, we hope that the peoples of the former Yugoslavia will be heard through the tribunal's work. I would add that so that the local people will gain greater understanding of our work, we have set up an outreach program, a program to inform people more about our work. And thanks to the political positive changes, first in Croatia, and now we hope in Serbia, and from the outset, of course, in Bosnia, we hope that the justice being rendered here in The Hague will be copied in local courts and will be able to work on the same concepts and the same case law, that is, basically, on the essential values of international humanitarian law.
The evolving presence of the tribunal in the former Yugoslavia provides an important link for peace and stability in the region. By building trust among the population and confidence in state institutions, the tribunal hopes to contribute to the emergence of a vigorous civil society where the rule of law is fully respected throughout the former Yugoslavia.
Comme procureur, j'aimerais pouvoir m'occuper de tous les cas, mais l'impossibilité.
As prosecutor, I would like to be able to concentrate on all the cases, but clearly I can't. So that's why we have to choose. At best, we have to limit our activity to the most serious cases. And that's why it's also very important to work together with the national systems of the various states so that they take up the cases we cannot. So we have very close contact with the authorities of the different countries because, of course, the principle that no one is above the law if he commits crimes is, after all, one of our concerns. And that is what we're doing. And then I also have to say, for instance, like in Kosovo, that they've set up a justice system which is part national and part international, which will allow the minor cases to be tried. As the former Yugoslavia rejoins a community of nations committed to the protection of human rights, a greater measurement of the tribunal's accomplishments will be possible. The International Criminal Tribunal for the former Yugoslavia and its sister court, the International Criminal Tribunal for Rwanda, have made substantial contributions to establishing a standard of justice against the worst atrocities of mankind. Against a backdrop of political resistance to accountability for violations of humanitarian law, this is no small task. The experience of these tribunals serves as a guidepost for the establishment of a practical and permanent system of international criminal justice.
L'audience est ouverte.
The tribunal has made very important contributions, first of all, through its jurisprudence. I think it is fair to say that when the statute of the ICC was negotiated, the most important legal source that delegates considered was the law and practice of the ad hoc tribunals, in particular the jurisprudence. And later, when the rules of procedure and evidence and elements of crimes were negotiated by the Preparatory Commission for the International Criminal Court, it has been very clear that the jurisprudence, the legal infrastructure of the ad hoc tribunals have by far been the most important sources.
By singling out and punishing the individuals most responsible for the serious crimes committed in the former Yugoslavia, the ICTY hopes to contribute towards reconciliation between the peoples of the former Yugoslavia.
I think that the work of the Hague Tribunal has helped people in Croatia to realize that defending your country is one thing, that the legitimate right to defense is one thing, but the crime, which must be condemned by the local legal system, by our public, and of course by the International Tribunal, is another thing entirely. Yes, there are different views, but if we talk about the Serb community, then there is no dilemma whether the crime should be prosecuted or not. However, the Hague Tribunal must be objective. It must not be subjective. Regardless of who committed the crimes and regardless over whom the crimes were committed. If there is a conviction in the consciousness of the people of Republika Srpska that the Serbs and Republika Srpska are being tried, there will be no stability, and the self-sustaining peace will not be established. The tribunal will not contribute. But if individual crimes on all sides and against each of the peoples are tried, this is what will contribute to stability in the region, to reconciliation certainly, and to peace, which we all want in some way. A criminal is a criminal, regardless of his nationality. Anyone who commits crimes against his fellow man should be pursued, arrested and tried. It is very important for people to understand that individuals and not nations are to blame for what has happened. The crucial matter to be grasped is thus that accountability is individual and not collective. I think, therefore, that the trials are very useful, because they will separate individual from collective accountability, because they will remove the collective guilt from particular peoples. So, from that point of view, they are very, very important. I don't think I can say something important about it. They can maybe catch these people who allegedly did things. I mean, I do believe that there were things on all sides, but to influence people in more important way, I don't know, it all depends on the people. I think that people understand what war crimes are, what it means to commit a war crime. But some people simply don't want to come to terms with this. They have one idea in their head, that this war was fought for liberty, and that war crimes were not committed by our side. But they are absolutely sure that the other side did commit the crimes. But I think that propaganda was very important in it. There was a time when you could constantly hear that only Serbs were committing the war crimes, I mean the Serbian side. And then in the end it was discovered that there were camps established by the Croats. So I think people do know very well what war crimes are, but they don't want to come to terms with it.